Did you know in Texas that if you don't probate a will within 4 years, you might lose the ability to control your loved one's wishes completely? I'm Karen Hayes. I have been in real estate in Texas for 4.5 decades, and I have seen this more times than I can count, especially when families are trying to navigate the loss of a loved one, sell the property, not knowing whether there's a will or there's not a will and where to even go from there. I am not an attorney and I am not giving legal advice, but I have closed thousands of transactions and helped families navigate this situation in all scenarios. So I'm going to work on a series for you so that you'll get to hear a little bit of everything. In your situation, there may be a will, there may not be a will. And depending on that, it's going to control how the sale of real estate happens for you. When someone dies without a will, which is called intestate, when someone passes without a will, there are many things that are important to understand. First, all of the family will need to get involved. So if there are issues involving a family member that is not available, lives out of the country, maybe they're in prison. I'm not kidding, I've closed those transactions. It's super important to understand that if there is no will, then clearly all of the heirs have to come together. And if one of the heirs have passed, then their children are involved. So I'm going to cover that situation. I'm also going to cover when there is a will and no one takes it through probate court for more than 4 years. So at least in Texas, we have a rule of 4 years from the time that someone passes to take the will through the probate courts in order to follow the terms of the will. And if you exceed that 4-year period, and let's say, for instance, one of the kids wants to move into the property and everyone agrees, oh, that's fine. They can live in the property until we can sell it, and we'll work on selling it over the next few years. Just keep in mind that you've got a 4-year period and you need to start the probate before the 3rd year just to make sure that you don't have any outlying issues that can't be resolved within that 4-year period. Also, it's important to know that if it's been more than 4 years and the court has to decide at that point, the will could become irrelevant, meaning whatever the wishes were may not be honored if the court chooses that there's a better path for the property to be distributed. As far as real estate goes, as far as a real estate asset, you can also do something that's called a muniment of title in Texas, where the courts still have to approve the sale, but in order to pass title, sell the property, the court can decide who can sell the property, basically, who has the right to sell the property. And if there's a spouse that survives, then typically that would be the spouse, but not in every situation. So it's super important to understand that with an attorney, how something like that would get handled. If there is no will, and everyone's aware that there is no will, then the only way that you can close a real estate transaction is to determine who the heirs at law are. So if there's a surviving spouse, then that surviving spouse already owns half of the property if they're entitled with the person who passed. So it's the person that passed interest, which is a half interest to the property, that is going to be determined. The person that is the surviving spouse, they still own their half. So now you have to determine how the half of the deceased party, how their interest is divided. And in Texas, we use what's called an Affidavit of Heirship. And you have to determine by many questions, really just the facts of the life of the person that passed. So that is a whole nother video, and I will create that video as well. But we are going to talk about really all of the facts of a case where someone has a will, no one knows where the will is, someone finds the will, and 4 years have passed. We're going to talk about when there's a will and it goes through the probate courts. It gets started, the attorney takes it through, and someone in the family contests the will, stating either the person was not of sound mind when they signed the will, maybe a will had been repurposed recently and changed so that for some reason someone else was added to the will or removed from the will, and another family member contests that. That can happen, does happen. I've seen it happen. Also, I've actually closed a transaction where it took almost 20 years for a family to come together through 4 separate attorneys, and honestly, I can't remember how many heirs. I think all in all there were 8 or 10 heirs, and 2 were minor children when it started after the death. And so that carried on for almost 20 years. I believe it was 17 and a half years or so, where those now were not minor children, they are adults, and everything had to be determined as far as following the will way beyond the 4-year period, way beyond that statute. But because it was in the courts, it had to resolve one way or another. So that was a really interesting situation. We got it closed, but it did take time. It did take a lot of structure, a lot of cooperation, and a lot of time. So really, time is what you're up against when you are the adult children of a deceased person, and it's your parent, or maybe it could be your aunt, your uncle, however, you're the final heir to them. All of these facts need to be understood before this person passes, so everyone's clear about how this can be handled. So I hope you'll join me. I am not just focusing on people 50, 60 and beyond with this. Of course, if you have a will or you're creating a will, and if you have children, adult children, they know that you have a will and all that would go with that. No one wants to talk about this. I understand that. It's just really hard to talk about it when something tragic happens unexpectedly. We are all going to pass one day, and all of a sudden you've got a situation where family is just trying to get the real estate sold. It could be 1 property, it could be 10 properties, but it's not going to close, and title is not going to transfer until a full title search is done, all the heirs are found, the will, if there is one, is located, the will goes through the probate courts, and if the will doesn't go through the probate courts, then everyone should understand here's what you're up against. So I hope you'll stay with me and join me in this series of videos. Again, I am not giving legal advice on any level. This is from my own experience over decades in helping thousands of people close transactions. I am a real estate agent today, and I would love to help you with any questions that you might have, that I can direct you to an attorney that can help you, that specializes in probates and wills and family living. And it's definitely a situation you don't want to have to deal with when you don't understand the facts of the case. So I hope you'll join me. Stay with me on this. It's probably going to be 3 or 4 videos that'll take us through this. It's going to take a little while to cover all these scenarios, but it's pretty interesting. And if you're in a state that doesn't follow the same rules as Texas, you definitely want to get with your attorney And just so you understand the facts of how this works, when you have a will, when you don't have a will, if you have a will and you go through probate court, and if you do not. There are those scenarios that it's really, really smart to get all that information up front. It's going to make a much smoother, much faster transaction for everybody and a lot less stress. Talk to you soon. I'm Karen Hayes. I am not an attorney, and I am in no way giving legal advice in the videos pertaining to estates and trust transactions. Although I've been in the title industry for decades, been in the real estate industry for decades, I just am not able to give any legal advice since I'm not an attorney. But I do base my information on my own experiences through closing many transactions and helping families navigate this difficult situation with wills, probates, trusts, and I am happy to help.